It's a great pleasure to be here. I'm Bill Yeomans, and I am moderating this panel on race and the law. Obviously, it's a substantial topic with lots of things to discuss, so let's get to it. Our panelists are going to try to help us get our arms around the topic in a variety of ways. And I'm going to start with a few introductory remarks and introduce the panelists. And then each panelist will speak for a few minutes, we hope about 7 minutes, after which we will have a moderated discussion, and then we will open it up to questions from all of you for the last 20 minutes or so of the panel. So to get started, on the doctrinal front, the Roberts Court has moved steadily and at times almost breathtakingly to restrict both the scope of civil rights laws and remedies in court, as well as the power of Congress to enact new remedies. Chief Justice Roberts' statement in Parents Involved that the way to stop discrimination based on race is to stop discriminating on the basis of race is a kind of startling encapsulation of the views of 4 justices who believe that the colorblind Constitution prohibits all consideration of race. Their view seems to be, and it's reflected in much of the conservative dialogue about civil rights and civil rights law, that we may have had a problem, but we passed a bunch of laws, things got better, and now it's time to move on. Mission accomplished. Indeed, one sometimes gets the impression that these justices think that the great evil is that we keep thinking and talking about race. I'm reminded of a recent comment by Justice Thomas in an interview where he said, "My sadness is that we are probably today more race and difference conscious than I was in the 1960s when I went to school. To my knowledge, I was the first black kid in Savannah, Georgia, to go to a white school. Rarely did the issue of race come up." In other words, I guess if we could just stop talking about race and being conscious of our differences, we could return to the racial harmony of Georgia in the 1960s. Thanks. But what this ideology has meant is an assault on remedies for structural discrimination. So in Ricci, the court warned us that the disparate impact standard of Title VII is likely in conflict with the Equal Protection Clause. The court has now taken 2 cases with the apparent goal of holding that the Fair Housing Act is not violated by a disparate impact. And now even Section 2 of the Voting Rights Act seems to be coming into the crosshairs. And in addition, as I mentioned, the court has shown disdain for the power of Congress to enact legislation to address contemporary problems. Obviously, nowhere has this disdain been more obvious than in its holding in Shelby County, striking down Section 4 of the Voting Rights Act. And of course, Congress sadly is in no shape to put up much of a fight. It has reached its least productive level in modern history. It is less capable, it seems, of passing legislation than it has ever been. So while we have obviously made progress, we seem to be at a crossroads. Problems of education, criminal justice, housing, employment, income, and wealth persist and all too often have a great deal to do with race. So we have fundamental choices about how to proceed. We can continue to resist doctrinal developments. We can work with what we have. Cases like Fisher leave some room to operate. We can try to come up with alternatives, new ways to address these long-standing problems. With that, let me introduce our panelists. And I will do so briefly because obviously it is such a distinguished group that if I gave each of them their due, we would be here well past lunch. So I'll work from the far right down, not on the ideological spectrum, but on the geographic spectrum. At the end is Tomiko Brown-Nagin, who is Daniel P.S. Paul Professor of Constitutional Law and Professor of History at Harvard. Before entering academia, she litigated and was involved in Parents Involved and Grutter. She's a prolific scholar, and in 2011 won the Bancroft Prize in U.S. History for her book, Courage to Dissent, Atlanta and the Long History of the Civil Rights Movement. Immediately next to me is Sheryll Cashin, who is Professor of Law at Georgetown University Law Center, where she teaches constitutional law and race and American law and writes about race relations and inequality. She previously worked in the Clinton White House, and her new book, Place Not Race, A New Vision of Opportunity in America, has received considerable attention and critical interest, and I think we'll be hearing more about it. To my immediate left is Gail Heriot, who is Professor of Law at the University of San Diego School of Law and is a commissioner of the U.S. Commission on Civil Rights. She teaches and writes in the areas of civil rights, employment discrimination, and torts. And previously, she has been in private practice and served as a counsel on the Senate Judiciary Committee. She also taught and was associate dean at George Mason University School of Law. And to my left on the end is Juan Cartagena, who is president and general counsel of LatinoJustice PRLDEF, one of the nation's leading civil rights organizations. He's a constitutional and civil rights attorney who practices rights and teaches on these subjects, including the political representation of poor and marginalized communities and the effects of mass incarceration. Let's start. Professor Brown-Nagin, let me turn to you first. Your current work addresses inadequacies that you see in the approach of elite universities to admissions. And I wonder if you want to talk about that or anything else you'd like to talk about.
You're first, I think.
You're first. I'm sorry.
That's the order.
Wonderful. Right, wonderful. Thank you. And thank you for inviting me to ACS to this distinguished panel. Here's my argument. Current iterations of affirmative action and many so-called class-based reforms are too blunt to do the additional work that needs to be done if we want to make our commitment in this country to social mobility, class mobility, more credible. And what I mean by that is that race-based policies don't necessarily reach those who are disadvantaged on the basis of class, and class-based policies don't necessarily reach the neediest students. Now, social mobility, class mobility, is the goal that I'm interested in advancing. Social mobility is important today, and I would emphasize that it once was integral to our conception of equality. Think about the fact that the Civil Rights Act was passed along beside war on poverty legislation. Think about the fact that original iterations of affirmative action were designed to integrate the union shop. Consider also that affirmative action policies in higher education originally integrated our flagship universities in the Deep South, bringing Black and Hispanic students who had no tradition of higher education in their families into universities like Texas, North Carolina, UGA. So originally, affirmative action addressed structural inequality. But there was a departure. And what I would emphasize is that the departure is not actually a recent departure. So it did not occur with Fisher or with Gratz. I would actually date it to Bakke, which might be surprising. Why Bakke, this case that now is held up as a landmark in access to higher education? Well, it's because of the diversity rhetoric, which is capacious enough to include students of color in higher education, but also capacious enough to confer a great deal of discretion on university administrators as to how to interpret students' diverse characteristics. And so what has happened, I would argue, is that universities have used their discretion to integrate under affirmative action policies in a way that's consistent with creaming. That is, they have included, they've turned to the Black and Hispanic, multiracial, biracial students from the wealthiest households, from the most well-educated households, and this is their diversity. Now, I will say to you that on the one hand, this is a welcome development. These students should be included, and I'm happy that they've been included. And yet, there are other students who are deserving. These are students whom I would call truly disadvantaged students of color, of great ability, who it is easy for selective institutions of higher education to crowd out, to be crowded out in the admissions process. And how does this work exactly? Well, it's not through what you might think of as nefarious means. It's because when admissions officials in the environment that we're in today, which is hyper-competitive, costly, compare the files of the most advantaged students to relatively advantaged students, so the kinds of students who are gaining entry through affirmative action policies, to these truly disadvantaged students, the third group of students are not likely to look as attractive. And why is that? Well, it's because of admissions criteria, SAT. It's because of the high schools that the truly disadvantaged students attend. It's because of social capital deficits. So those students tend not to know how to package themselves. And I could go on and on and on. So this is how the creaming occurs. So the question is, what to do about this if you think that there's a problem here? And here's my proposal, and there are many good proposals out there. What I've written about recently is the suggestion that selective universities should prefer first-generation Pell Grant eligible students in admissions, in financial aid, in institutional outreach, and in institutional support. So all of those points are vital if these students are to be included, if universities are to promote social mobility. So the question, of course, is why first generation? And it's because it is a proxy that is targeted and analytically precise. It's a proxy that reaches students who are educationally disadvantaged. It's a proxy for racial disadvantage, for place, for culture, for all of the things that are important in my view. This is where we find the roots of disadvantage. These students, many of them are very talented, but again, it's easy to crowd them out. So I won't go into the details of the proposal, in part because I see a big red stop sign. But I will say that I think the jurisprudence that has developed recently, obviously there are limitations to it, but at the same time, it could be a helpful nudge to return to the complex conception of equality that originally motivated the civil rights community. That's what I'd like to see. Thank you.
Professor Cashin?
I'm glad I got, yay, hold up the book, thank you. So I don't have to appear shameless. It's nice to come after Tomiko because she sets me up very well. We both are very similar in our skepticism about the bluntness of using race in affirmative action. Our prescriptions are a little bit different. I'm arguing that race-based affirmative action should be reformed to help those that are actually disadvantaged by segregation, and that why segregation? Because segregation where you live is heavily tied to access to quality education. Only 42% of all Americans today live in a middle-class neighborhood, and that's down from 65% in 1970. Why is that? Because increasingly the affluent and highly educated people, like the folks in this room, are living in their own communities, often what I call gold, gold standard neighborhoods. You all know what the gold standard neighborhoods are, and if you can buy your way into a neighborhood like that, you automatically, or your children automatically have access to highly selective K through 12 education that sets you up very well to enter selective higher education. Everybody else outside those networks faces serious structural disadvantage, and Black and Latino kids, only about 30% of Black and Latino kids live in a middle-class neighborhoods. And among those structural disadvantage are attending under-resourced schools with less experienced teachers, fewer high-achieving peers that raise expectations and spread around what I call college knowledge, just knowing how to negotiate the application process, and peers that model habits of success. Also, often you're exposed to violence and have to negotiate that. These are kids, and yet in every neighborhood, in every school in America, there's a valedictorian. There are high-achieving kids out there that are capable of doing the work, and they're the ones who need and deserve a leg up in admissions. Now, for some time, folks like Rick Kallenberg, who's a friend and a classmate from Harvard Law School, have been arguing for class-based affirmative action, and I argue that that alone is not sufficient. Family income, particularly alone, doesn't capture these structural disadvantages that I argue are causing opportunity hoarding in this society. Place, where you live, locks in advantages and disadvantages that are reinforced over time. And by the way, this was a shocking statistic I came across in my research. There are only 17 counties in this country where more than half of the population are college graduates. College graduates used to be much more dispersed in this society, and so increasingly we have a society that works for people who are already advantaged, already in these advantaged networks. One of the reasons why I prefer using place, not race, beyond helping kids who are actually disadvantaged, is that I think this would have the benefit of encouraging rather than discouraging cross-racial alliances among the majority of Americans who are locked out of resource-rich environments. I cite in the final chapter of my book, which is entitled Racial Reconciliation, the coalition of strange bedfellows that supports the Texas 10% plan. And I want to emphasize, we as progressives, we have to confront and deal with the reality that there are a lot of angry, resentful white folks out there. There's rising white anxiety. The majority of whites, it's not comfortable to say this, but it's true if you look at the polling, feel that the gains of the civil rights movement have come at their expense. They look at government as for everybody but themselves. And there are politicians and radio talk show hosts that cannot resist stoking that resentment. And progressives, I argue, need to be overt in trying to build alliances between people who represent struggling white folks, if not struggling white folks themselves, and people who represent disadvantaged communities of color. And the Texas 10% plan illustrates this. The plan, which came about only after a court banned the use of race, created this context for creative, innovative thinking. Blacks and Latinos in the Texas legislature managed to get that passed with the lone vote of a white rural Republican who, when they showed him the data, became convinced that his kids, his constituents, weren't getting into the UT system. And of course, people in advantage districts that had dominated the admissions process at UT have repeatedly tried to get that program repealed, but the coalition of strange bedfellows that supports it has grown, and they have insulated it from repeal. So now people in advantage districts can no longer hoard an important, critical public resource that's subsidized by everyone. And that's the kind of transformative politics I'm arguing for. I think we have to get much more creative to think about policies that create broader opportunity for everyone and also create a saner politics. I don't only argue about place, but my place proposal is if you come from a neighborhood, if you're high achieving and you come from a neighborhood or school where more than 20% of your peers are poor, you deserve a leg up in admissions. But I also argue that the admissions process should be scrubbed of any practices that reinforce advantage and aren't truly tied to merit. And I could talk about that more in the Q&A, but standardized tests should be optional or not used at all. Financial aid should return to being based solely on need, not so-called merit. Legacy preferences should be abolished. And any institution that is sincere about achieving real diversity and inclusion should work with a partner like the Posse Foundation, like Questbridge, that has become very good at finding high-achieving kids who can do the work. And I'll stop there.
Thank you. Professor Heriot.
Thank you. Good morning, ladies and gentlemen. I think I have been invited here in my capacity as the loyal opposition. Nevertheless, there's a lot of what's been said so far that I can agree with, and some that I disagree with. But one of the things I'm here to do is to say I think you're asking the wrong question. The issue is not whether race still matters. I mean, matters to what? You know, to whom? The real issue is whether the best way to promote a free, racially integrated society that I think we all aspire to is by pursuing race preferential affirmative action policies. Let me start with race preferential admissions policies, which I think are almost certainly doing more harm than good. The very large preferences that are now routinely employed by colleges and universities produce fewer, not more, black scientists, black engineers, black medical doctors. They produce fewer black college professors, too, and very likely fewer black lawyers. This is a serious policy failure. Before I get too far, let me say that I'm not here to argue against outreach. Outreach is not the problem, nor am I here to argue that schools should consider only academic indicators, like only the SAT, in evaluating applicants. There are lots of ways to measure talent, though I would say that race is not one of them. Let me get back to my main point, though, and that is that race preferential policies don't work in the admissions context. How can that be? How can giving minorities a friendly leg up actually reduce the number of minority professionals? Let me explain. One consequence of widespread race preferential policies is that underrepresented minority students end up distributed among universities in very different patterns from their white or Asian counterparts. When the highest schools on the academic ladder, when they relax their admissions qualifications in order to admit more minority students, schools one rung down must do likewise if they're going to have the number of minority students they feel they need to have. The problem is then passed on to the next rung on the ladder, and they respond similarly. As a result, underrepresented minority students are concentrated at the bottom of most selective colleges and universities today in terms of their entering credentials. The problem isn't that there are no academically gifted minority students. Of course that's not true. But they are right now not currently enough at the very top tiers to satisfy the demand, and efforts to change that have created credentials gaps up and down the ladder at selective schools. For example, we learned in connection with the University of Michigan's policies back during the Supreme Court litigation involving Michigan, that the college there was giving underrepresented minority students a preference that amounted to an entire letter grade, all other things being equal. An African American or Hispanic student with a B average was treated the same as an Asian or white student with an A average. That's not a tiebreaker in otherwise close cases. Those preferences are very large, and since 2003, they've actually gotten larger. The problem is that entering credentials matter, and students whose academic credentials are well below the average for a particular school usually earn grades to match. Sometimes that's masked by grade inflation, of which there's a lot. But nevertheless, while some students are going to outperform their entering credentials, just as some students underperform their entering credentials, most students perform in the general range that their entering credentials suggest. And anyone who thinks differently is engaging in wishful thinking at student expense. No serious supporter of affirmative action denies that there is this connection between entering credentials and grades. The strongest evidence of the backfire, and that's what matters here, it's not the grades in itself, but the strongest evidence of backfire comes from science and engineering. Contrary to what some people expect, college-bound African American and Hispanic students are just as interested in majoring in science and engineering as white students, actually a little bit more so. Less than Asian students, but a little bit more so than white students. Nevertheless, these are difficult majors, and many students of all races end up abandoning them. African American and Hispanic students jump ship at much, much higher rates. Now, it's not surprising that those students who give up on science and engineering, again, of any race, disproportionately have lower entering academic credentials. But what some people do find surprising, and this is key to what I'm saying, there are now 3 in-depth published studies by researchers at Dartmouth, the University of Virginia, and Duke, among others, plus one still unpublished study, that have all demonstrated that part of the effect is relative. An aspiring science or engineering major who attends a school where her entering credentials put her in the middle or the top of that class is more likely to persevere and ultimately succeed than an otherwise identical student attending a more elite school where those very same credentials put her towards the bottom of that class. Put differently, preferences hurt in this context. They do not help. And the difference is not trivial. We would have a lot more successful science and engineering graduates if we were engaging in race-neutral admissions policies. Another example of this is that historically black colleges and universities turn out far more than their proportionate share of science and engineering majors. A similar study by Stephen Cole and Eleanor Barber shows that minority students who attend colleges where their entering credentials put them at the bottom of the class do not aspire to go on to graduate school and to become college professors in the same numbers as their minority counterparts, again, same entering credentials, who attend schools where those credentials are putting them, where those credentials put them more towards the top of the class. And, you know, if you go to a school where you get A's, you like school and you want to go on to graduate school. And that's what we're seeing from the empirical evidence. None of the results of these studies has even been controversial. No one has rebutted any of it. The only mismatch study that has received any criticism is Rick Sanders' law school study, where data is hard to come by. But some of the very same people who criticized that study, which comes to the same conclusion, that preferences hurt, that we would have more black lawyers if we did not engage in these large preferences. The very same people who criticized the study have tried to prevent him and his ideologically diverse team of investigators from getting data from other sources. That speaks volumes. Now, I could go on to another wrong-headed policy, I believe, if I had the time. I'm not sure that I do here, but let me just say a couple of words about disparate impact liability in employment. Again, the empirical literature is far less developed in this area than it is in the college and university admissions area. We don't have that much, but insofar as there is data, it suggests that, again, we've got a policy that backfires, that disparate impact liability in employment does not open opportunity for minorities. Rather, if it does anything, it may actually decrease that. When employers are told, for example, that they can't administer paper and pencil tests in employment situations, measuring an applicant's ability to do math or so, what they're sometimes going to fall back on, although it's illegal, and although I would love to prevent it if I could, but what's going to happen is that some employers will then engage in stereotyping, and that ends up hurting minority applicants rather than helping. Similarly, when the EEOC makes it difficult for employers to conduct criminal background checks, sometimes what that's going to do then is cause employers instead to simply engage in stereotypes, move their businesses to the suburbs. We need to think these things through more carefully, and my time is up.
Thank you. Juan, Cartagena. I wonder, having heard the others speak, if you have some response, particularly to the question of whether there is benefit to be gained from race-conscious policies in education or elsewhere.
I think the biggest benefit is that we speak about race openly, that we speak about race clearly, and we speak about racial equity in virtually all the work that we do. I understand some of the points about using race-neutral concepts to get at some of these same ends. I would have been probably a beneficiary of race-neutral concepts, no matter how you cut and slice them. I probably would qualify on each one of the Fisher 7 factors. And I'm an affirmative action child who got to 2 elite institutions. I call them expensive because it took me 14 years to pay them off. Institutions in the 1970s, and I know they relaxed their admission standards when they took a person like me and people like me. I wasn't the only one, but they surely didn't relax their graduation standards. So I think the benefit of dealing directly with race, as blunt as it may seem at this point in time, despite what we know is a very conservative Supreme Court, is that it forces us to front and center discuss these issues. The coalitions that create racially equitable paradigms to discuss, for example, sentencing in criminal justice areas in Connecticut were done with whites, blacks, and Latinos all talking about race openly to make sure that new laws in the criminal justice field don't exacerbate the mass incarceration of blacks and Latinos in that state. It is possible to create coalitions that are premised on race. I do definitely agree that to the extent we're still allowing institutions to use exclusive measures like the SAT for admission, then that exacerbates the problems that we're talking about before. But in many ways, discussing race openly, including using racial preferences, is more preferable, in my opinion, than using alternative means to try to get the same end, in which we're now talking about other issues that still don't deal with the elephant in the room.
Okay, thank you. Let me turn back to this side of the panel again. And you have both suggested inadequacies in the way that affirmative action is approached currently. But I wonder if you have some response to this notion that race-conscious affirmative action has backfired, has been harmful for minority students.
Yeah, I have a couple of reactions to this mismatch argument. The first, I think, and most critical reaction is I think that a lot of the data that, I'm sorry, I'm forgetting your name.
Gail.
That Gail has brought out and that's been coming out in studies reflects the the fact that the admissions officers, I think, are focusing on the wrong things in the admissions process. In my book, I cite a study by Doug Massey and some other folks that looked at college completion at 28 selective schools. They looked at the factors that predicted success, not just of blacks, but of all races, of all of the students. And the #1 predictor of college success was cumulative high school GPA. The #2 strongest predictor of college success, i.e. completion, was the willingness to do the work, to delay gratification, to do the work. I was that kind of kid. I had a fair to middling SAT score, but I was the valedictorian of my high school, and I would be in the library on a Friday night. I was a nerdy kid. And the SAT score was nowhere to be found. It wasn't even the 5th or 6th predictor. It was nowhere to be found. And you know, the Posse Foundation is a good example of what you get when you focus on the right factors. Posse is more selective than Harvard. Only 4% of the people who apply for a Posse scholarship get it. On average, they have about an 1100 SAT score, but these are kids who have grit, who have resilience, who arrive at a school with their posse, have had some acculturation to college life, and you know, when they arrive, they're not succumbing to a stereotype threat. They feel entitled to be there. They feel good about themselves. They've got their posse, and they are enormously successful. So some of it, I think, is that, you know, schools need to get off their preoccupation with their position in U.S. News and World Report and stop overemphasizing SATs. Kids who graduate with a straight A or very, very high grades tend to repeat that high performance. And there is a much larger class of Black and Latino, even poor and Black and Latino kids who are like that than elite higher education would imagine, but they're not looking in the right places, and I emphasize that as well. So we could do better with finding kids who have this grit and resilience and high GPS. The second thing I'd say is, you know, I was on a panel yesterday with an economist from the College Board who said that something like 50% of African American SAT scores attend schools that are lower than their credentials are, than they're worthy of. And African Americans in particular do better when they're in more challenging schools, you know, if they've got solid credentials. So that's my reaction. I think we have some commonality here, the three of us, in terms of race is too blunt, and in some ways lets people off the hook from doing the hard work of rethinking what really counts as merit.
Right, and you know, Sheryll and I are so on the same page in many ways that I would endorse much of what she said, and add that I think it's really important when we're considering the performance of these students and all students to think about the qualitative factors that promote success in our students. So I don't think that entering credentials tell us the full story about why students perhaps are interested in being engineers or professors, but then they decide that they don't want to pursue that track. What about the nature of their relationships with their professors? What about the nature of the culture of the institution? So when you invoke historically Black institutions, I think about the extent to which the environment is likely to be nurturing in a way that a lot of the selective institutions are not going to at least have a reputation for being nurturing. And why is that? Well, I have to say, race probably has something to do with it, which is a way of going back to Juan's statement. To say that the policies are too blunt, too to reach the full complement of students that I think it's important to reach is not to say that race doesn't matter. I do not endorse that position. Race matters in many, many ways. The question is how to push universities, how to nudge universities themselves to be more honest and to really play the role that I think they ought to play in our society, which is promoting social mobility and not just doing what they do now, which is keeping society the same as it is.
Thank you. Let me ask one more question. Professor Cashin mentioned the 10% plan as an example of something that has brought people together and has built a coalition. This is, for any of you who don't know, this is in Texas in the wake of Hopwood, which eliminated race from consideration in admissions in the Texas system. The 10% plan was adopted, and basically what it says is that anybody who finishes in the top 10% of their high school class gets admitted to a flagship university in Texas. Because, of course, Texas schools are so segregated, that produces a fair amount of diversity. But a couple of questions about that. One is, it does seem to me to be the sort of the ultimate blunt approach. It's not fine-tuned in any way, and I think the University of Texas agrees with that. But second, I would also pose the question to Professor Heriot, whether that kind of plan is acceptable, is a good idea, whether it's constitutional given that it was adopted with a specific racial purpose to increase minority representation. So I throw it open.
Okay. Socioeconomic preferences, generally, I want to integrate into that a little bit. But in terms of a 10% plan, I think it's true that some members of the Texas legislature voted for this because they thought it would have a particular racial effect. And if that were the predominant reason for the 10% plan, I would consider it to be just as unconstitutional as racial preferences would be. It's simply pretext. I think actually, though, a lot of the Texas legislators voted for it because they you know, as now I forgot. Sheryll, as she was saying, it's a weird kind of coalition. You know, it was a weird coalition, but I think it actually was a very healthy coalition in some ways. You know, I believe that it's true, that state universities, the whole purpose of a state university is to make higher education available to people who otherwise might not be able to afford private universities. I mean, that's why they were established. So of course I want to make sure that state universities are in that situation. And for many years there was kind of a weird political alliance in Texas. You know, Texas has a long history of a group that sort of doesn't want the university to become too elite, and a group that did want it to become very, very elite. And one of the leading elements of that coalition is always the faculty. They like it. You know, it's got the U.S. News aspect to it. And a coalition of affirmative action supporters plus people who like the idea of a very elite university got together, and that dominated for a while. Then the Hopwood case comes along and says, no, you can't have racial preferences. And then you get kind of a different coalition that I think to some degree has operated to bring down the overall level of eliteness of Texas schools, because again, contrary to popular belief here, SAT scores do matter. And they do in fact predict a lot. When schools are telling you they don't predict that much with regard to what they call success, that is graduation, we're forgetting the fact that people go from tough majors that are going to lead to elite careers to majors that don't lead to those careers, and like that's important. If we can have 30% more black physicians, black engineers, that's big. That's a big effect. And the mismatched literature is telling us that, look, you know, of the people who are interested in majoring in science and engineering, we could actually up the numbers a lot by engaging in race-neutral admissions. That's big. But Texas, I think, basically has brought down the overall level of eliteness, and that may indeed, you know, help on the mismatch problem. When it comes to socioeconomic preferences, you can run into the same problem there. You know, I'm much more sympathetic to socioeconomic preferences than I am to race preferences. However, You're not going to be doing anybody any favors if you admit them to a university where their entering credentials put them towards the bottom of the class. They will not be more successful. They will be less successful than what they would have been had they gone to a school where they had a fighting chance of being at the top of the class.
Just very quickly, I want to first make it clear that these 10% plans, they're not the only thing that I think needs to be done, but what is nice about the 10% plan is it does screen for the factor that research shows is most predictive of success, high cumulative high school GPA. And I'll leave it at that.
Okay. I'm gonna change topics slightly now. and I want to go back to Juan, Juan, you've been doing a considerable amount of work regarding race in the criminal justice system, and particularly both the effects of mass incarceration, but also the interaction between communities of color and law enforcement. And I wonder if you could talk to us about that a little bit.
Sure. One of the talking points that I took away from the description of this panel is whether we should operate in a race-blind approach to the issues of the country. And that I would submit to you that there's tons of evidence that demonstrates that in the area of law enforcement and criminal justice application of the laws of the criminal justice system, the racial profiling that occurs across the board at so many levels indicates we cannot operate in a race-blind position. The actions that are being taken by many police departments throughout the country are engaging in intentional racial profiling that it cannot be explained by the suspect information regarding crime data or criminality among those same Black and Latino populations. From the days that from the Supreme Court was addressing issues of racial profiling in the cases as way back as U.S. versus Brignoni Ponce many years ago, in which along the border the question was whether or not the use of race can be a factor in stops along the border. And the Supreme Court ruled, yes, you can use race, but it cannot be the primary or the only factor in deciding whether or not you can stop somebody along the border. We have seen a development of quite a number of interesting manifestations of police tactics that appear to try to create neutral qualifications or justifications for their stops, which in reality cannot be justified. So the whole notion about whether you're driving in the car and you're sitting erect in the car, and if you fail to look at the police officer who's driving in your opposite direction, you are obviously suspect. But if you do look at them, you're also obviously suspect. If you drive at the speed limit, you're suspect. If you drive below the speed limit, you're definitely suspect. If you drive slightly above the speed limit, you're also suspect. The question again is how policing morphs into trying to create these race-neutral qualifications or justifications that in reality, once you scratch the surface and analyze the data, cannot be justified that way. So I am one of a team of attorneys in the massive, the biggest racial profiling case that we can identify in recent history, the New York City stop and frisk case. So my office works on one of those lawsuits that was combined with the Floyd case. The Floyd case was advanced by the Center for Constitutional Rights, and they have done an amazing job at advancing this case from the moment they got their hands on it in various permutations, even before the Floyd decision was rendered last year. To them, we owe a lot of credit. Our office works with the NYCLU, Bronx Defenders, and others to address what we call hallway stop and frisk. This notion that you can actually be arrested for trespass in your own building because you don't have ID. Our clients simply want the right to be able to throw out their garbage without ID. You know, go to the elevator, meet somebody at the elevator well without ID. So the outrageous nature, the worst perverse application of stop and frisk occurs in the hallways of residents or their visitors, or guests, who cannot justify their presence and therefore get arrested for the ridiculous charge of trespass. But you all have heard about Floyd, and Floyd is this massive challenge to the 4.4 million stops, the incredible large number of stops across the board. And I just want to refer to two parts of that opinion by Judge Schindler, because it capsulizes in many ways what I'm talking about with respect to how the police departments in this country are trying to justify what is clearly racial profiling, intentional racial profiling, with alleged neutral reasons for its manifestations. She starts off by recognizing that the large number of stops and frisks in the city of New York over the course of so many years cannot be justified because they result in no summonses being issued and no arrests being made. Clearly 88% of the time. So 88% of the time, we're talking about millions and millions of stops that result in no action that can result in any kind of criminal repercussion. So the 12% hit rate, as it's deemed in the jargon, she also analyzes that further, and she says it's actually overstated. Because many individuals, 16% of the individuals who actually stopped and charged with a crime, it was marijuana possession. And in New York City, they were charged with marijuana possession on the premise that if they asked you to open your pockets and empty your pockets, you are now exposing marijuana, if you have it in your possession, to the open air, and that becomes the crime. Because possession of marijuana in New York State has been decriminalized for many, many decades. So 16% of that's thrown out. People will be getting stopped for summonses or warrants, and you can't tell whether or not a person walking down the street in New York has a warrant just by looking at them. So we also have you have the phenomenon in which, you know, if you're really looking for weapons and you're really looking for drugs and controlled dangerous substances in that regard, then the data demonstrated they were slightly more likely for whites than blacks or Latinos who were stopped under the 4.4 million stops to possess contraband, illegal drugs, and to possess guns. So if you look from the premise of what's effective and what's not effective as a policing tactic, those were some of the issues that were being raised in the case. But in many ways, the heart of the case comes from the experts. Dr. Jeff Fagan produced an analysis in the stop and frisk case that basically used a combination of reported crime, who's calling the police precincts for alleged crime in various neighborhoods or particular buildings, and population, as a benchmark for understanding the racial distribution of these police-citizen contacts. The city, on the other hand, tried to argue that the stops and frisks were justified based on crime suspect data. That is, since most people who commit crime in New York City were either black or Latino, it justifies the fact that stop and frisk is directed at them. Suspect race description data was the city's experts' reliance. So this is what the judge said. I conclude that Dr. Fagan's benchmark is a better choice. The reason is simple and reveals a serious flaw in the logic applied by the city's experts. There is no basis for assuming that the racial distribution of stopped pedestrians will resemble the racial distribution of the local criminal population if the people stopped are not criminals. The city defends the fact that blacks and Hispanics represent 87% of the persons stopped in 2011 and 2012 by noting that, quote, approximately 83% of all known crime suspects and approximately 90% of all violent crime suspects were black and Hispanic. This might be a valid comparison if the people stopped were criminals or if they were stopped based on fitting a specific description, but there is insufficient data to support either conclusion. Again, because 88% of the stops resulted in no criminal repercussions. So effectively, and this is the heart of what she ruled in respect to the Equal Protection Clause, because she ruled on both grounds. It was a Fourth Amendment violation, unreasonable searches and stops and seizures, but it was also a violation of the Equal Protection Clause. And I'll just finish with her finding on the Equal Protection Clause. That goes to the heart of what I'm trying to say. Based on the evidence summarized, I find that the NYPD's policy of targeting, quote unquote, the right people, because that was the jargon used by the chief of police, Chief Esposito, on the stand, encourages a disproportionate stopping of the members of any racial group that is heavily represented in the NYPD's crime suspect data. This is an indirect form of racial profiling. But it's equally clear that it is impermissible to subject all members of a racially defined group to heightened police enforcement because some members of that group appear more frequently in criminal complaints. The Equal Protection Clause does not permit race-based suspicion. if the question is, does race still matter, or the question is, should we operate in a racially blind approach to the issues of America, and today I would submit to you that we cannot address these issues in a racially blind way when policing decisions, law enforcement in particular, and in many parts of the criminal justice system, not only just produce racially skewed outcomes and disproportionate outcomes, but in many ways produce those results because of illegal, intentional racial discrimination. That's really what I wanted to add to the panel's discussion.
All right, thank you very much. Okay, so now it's time to hear from you about race mattering. And so I ask that you wait for a microphone to come to you so that we can be sure to capture your question, and that you put your statement in the form of a question. So do we have a microphone? There we go. We have people all over with their hands up.
So the panel has talked about some interesting ways so that underrepresented and poor minority students can access higher education despite their relatively poor preparation in K through 12 schools. Is there a role for the legal system to play in improving those inner city K-12 schools so that it's not as much of an issue once you get to college?
Well, sure. Let me jump in here. And in answering your question, I want to underscore that we need to keep distinct the idea of making claims for racial discrimination where there are cognizable claims, which I would fully support, so the kinds of things that Juan is talking about, and situations where those claims are not viable. So, for instance, for those of us who have concerns about over-reliance on the SAT, there is no cognizable claim, viable claim. But in the context of K through 12 education, sure, there are lawyers who have brought litigation that's really important. There's funding litigation. There are cases that have been brought about how students, including minority students, poor students, are deprived of access to AP classes, are deprived of the most highly credentialed teachers. There's just that ruling out in California. So there are claims that can be made, yes, about the quality of K through 12 education to help lift those students up, and I would endorse that. It's ongoing. A part of the problem here is that the litigation and our conversations about access to higher education are actually cut off from the conversations that we have about K through 12 education and those students. And in part it's because of the kinds of things that Sheryll and I have been talking about, that the pool of applicants, they're actually two different, are thought of at least as two different pools of applicants, is what I would say.
I just want to quickly add, my favorite case I like to cite is the Chef case.
Yes.
So in Hartford city schools, most of the population in Hartford, Connecticut are black kids who live in high poverty neighborhoods, but because of a lawsuit and a movement, a multiracial movement of parents who want and like diversity, 45 magnet schools have been created that allow black kids in high poverty neighborhoods to go to a high quality school decoupled from where they live. And there's an example of a strategy that widens the access to highly selective K through 12 education.
Okay, thank you. Please.
And since I am obliged to put this in the form of a question, the question is, if anyone has any interest, would you be interested in talking to me about the history of affirmative action in the state of Texas? I'll just say very briefly, the reason I consider myself qualified is that I was the head of affirmative action at the University of Texas School of Law from 1974 through 1989, and then at St. Mary's University School of Law from 1989 through 1998. And those were the two eras in which those schools were very successfully integrated one had 3% Hispanics when I got there and 42% when I was fired for having made it into a Mexican law school. And in the former case, I think we had spectacular success in affirmative action, and we went through all the phases. I was very active in connection with the Bakke litigation, and again, subsequently, I must have written more articles, both in law reviews and in newspapers about Hopwood than anybody else. And I can tell you that what works is good old-fashioned, well-intentioned, affirmative action that takes into account everybody's credentials and everything else about that person and provides proper support systems and recruits some superstars from the classes concerned and pays them immensely to come so that the whole group has an amount of credibility. I can tell you all about it, but I know I could just have to keep this a question, so I hope that's, that's the end of my question.
Thank you.
If I could respond very quickly, there's always going to be another Abigail Fisher. The same group that recruited her is actively recruiting plaintiffs to sue Harvard, the University of North Carolina, and the University of Wisconsin right now. And in the Fisher case, the Supreme Court has put a heavier onus on schools, narrow tailoring. If they get sued, then they have to show that there are no reasonable race-neutral alternatives. The Schuette case has made it clear that if a majority of people in a state want to vote to ban affirmative action, they can. And there are 3 states now. We have 10 bans already. There are 3 states now where people are organizing. So this is the reality. This policy is on life support. Race may work to get some kinds of diversity, but the reality is, if you care about this policy, progressives need to get some policies in place that can create diversity. And if you can get close, and there's studies that have looked at states where there have been bans, you can get close, particularly when you redo the admissions process and de-emphasize the standardized tests. Then I argue you should, and you may be forced to.
These organizations, by the way, are recruiting Asian plaintiffs, Asian women plaintiffs, in order to, I would suggest, tear apart the coalition of people of color. And it's effective, pretty effective.
This is addressed to Professor Heriot, but anyone, please feel free to weigh in. So Professor Heriot, for those who don't know, you submitted a brief in Fisher that largely echoed Professor Sanders' brief regarding the mishmash theory. And your 2 briefs were met with a really big response brief from a big coalition of law professors who are experts in social science, Daniel Ho, Ian Ayers, Gary Kang, all those. So it gets into a larger question of, is this the space in which lawyers and future lawyers should be operating in when it comes to the issues that are present itself in Fisher? Or are we kind of narrowing ourselves when it gets into this contestation among empirics when we're dealing with, the issue like race and affirmative action that has so many other larger socio-political contexts to it that are operating here. So,
I don't know how we can avoid it.
Is that the question that answers that answers the legal question of the 10% plan and everything?
When we're talking about racial preferences, we start with a baseline of a very, very strong presumption against any kind of race preference, and so that's what strict scrutiny is all about. And given that, when they litigated the Grutter and Gratz cases, they litigated it basically from that standpoint. And it ended up being a mistake for those who were against preferences to say, simply it doesn't matter. It doesn't, the facts don't matter as to whether or not this is effective. But they laid off that issue, and as a result, the Grutter case went the way it did. And from the standpoint of those who think this isn't working, to not argue this isn't working is a mistake. If these studies are correct, then this has just been a terrible mistake, because I don't think that anybody would support racial preferences if the result is that we have fewer black scientists, fewer black engineers, fewer black college professors, fewer black dentists, fewer black law professors. That's a serious problem.
There's a lot of hands up if you want to bring the mic.
Then I think you want to think about that really hard.
Question too.
Okay, go ahead.
Because it was mentioned about, now we have to talk about paying for college education, and it was mentioned, Professor Cashin, about not merit-based, but more about Pell Grant, but those high-achieving students. So it sounds like, how do you plan on trying to get the money to those students without merit-based at all?
Well, part of it is shaming institutions. Do you realize that today there's a limited pot of financial aid dollars, but more aid is assigned based on merit than need today? You know, in the Ice Age, when I went off to college, financial aid was based solely on need, and you had a relatively small percentage that got merit scholarships. All of this is driven by U.S. News and World Report. So part of it, what I do in this book is poke my finger in the eye of elite education and say, shame on you. You're more concerned about your rankings in U.S. News and World Report than helping the lowest income students who are least able to take on debt. All right, so that's part of it. It's just that, you know, allocate your dollars based on need, not merit. You can make that decision. And actually, a lot of very elite schools are moving away from need-blind admissions. So yes. I'm just trying to shine a light on this.
Hello, I am a current law student at the University of Texas, and I'm on the Texas Journal of Civil Liberties and Civil Rights. And we had a Diversity in Education Summit this past spring, and we spoke with admissions officers from the University of Texas General Undergrad Institution, and additionally our counsel in the Fisher case. And basically the data is saying that the top 10% plan is not working. It does not bring the percentage of students of color that it should. So I was just wondering if you have a response to that data. And the admissions office was saying that what they've had to do is really, really reach out to students of color in their communities and try really hard to get them to apply, because I think applications and admissions have gone down or have not increased whatsoever since the adoption of the plan.
Well, I've said it's not the only thing should be done. Again, I think SAT tests should be optional. The UT should be partnering with organizations that make it their business to find high-achieving kids that can do the work, like Posse, like Questbridge. The admissions process should focus more holistically on GPA. You know, I mean, that you just have to keep trying, right? The Texas 10% plan is a nice thing to have, but there are other things that can be done and should be done. And then there's the financial aid piece as well.
Hi, as a law student, and certainly with regard to STEM fields, if success of minorities is ultimately to be promoted, would it not be better to do well at an elite institution with better opportunities than to be at the top of a class that's at a lesser institution? To paraphrase one of my professors, you don't want to be at the top of a mediocre heap.
But the data shows otherwise. That in fact you're better off. You know, there's a trade-off between grades and the eliteness of the institution. And what happens is, for example, if you've got a student who is, say, middle class and was in the top 10% of his high school class and aspires to be a physician, and he's got a choice. He can go to Princeton or he can go to Penn State. And you take two identical students. The one that goes to Penn State is more likely to get into medical school and to fulfill that dream, and will have, on average, higher earnings. I mean, that's what we can, you know, we've got empirical data on that. The earnings will be higher to the one that went to Penn State, or at least more likely to, than the one that went to Princeton, all other things being equal.
Hi, my name is Jessica Smith. I am a UCLA graduate, right after the year that we only accepted 96 African American students. And the process by which I entered the university was through a holistic review, since affirmative action was banned in the early 90s. Do you think that the holistic review in looking at students' GPA, activities, their personal statements, also inclusive of race, is a better way in creating a diverse university?
Well, I will say the reason that I advocate a policy, and I don't know that this would, if you're talking about undergraduate or the law school. The reason why I advocate a policy that focuses in a very targeted way on the specific group of first-gen students, and there are a lot of first-gen students out there who are very talented, is because holistic review can leave in place a tremendous amount of discretion for university officials, and it doesn't necessarily yield the kind of racial diversity that some are seeking, which is why when the young woman says that top 10% isn't working at Texas, I don't know precisely what that means. Obviously, there are, when you say it's not yielding the number of percentage of people of color that the council wants, I'm not exactly sure what he wants and how he's thinking in terms of critical mass. All of those definitions matter. But if you want to reach a certain group of students, disadvantaged students, you actually have to use criteria that are targeted at disadvantaged students, okay?
Right.
So that's what you have to do.
Hi, my name is Peggy Lee. I'm a staff attorney at Legal Services of Northern California, and I'm part of the Race Equity Project there. I was doing a presentation recently, and I was talking about intersectionality and being a woman of color in the legal profession and the policing of women's sexuality and things like that. And I wanted to pose a question that I had that I didn't quite know the answer to. There was talk about how to make sure that there are more people of color and minorities in employment, not just in the game, but at the upper echelons, since we know that while there may be, for example, a lot of Asian Americans in college, in the college settings, there's a very few percentage in management or executive positions. And so the question that was posed to me is, there's been all these studies that have been done on, when you see resumes and you change the name, but everything else being equal, minority applicants just don't get into the game. And so that there's this kind of conflict of, should we have a colorblind type of application process, or should we take into account race and all these other elements that may prime bias? And how do we and if we do want to have some type of applicant or interview style that takes into account your background, how do we make sure it doesn't prime all these biases and stereotypes? So, because I do believe that it is important to have a holistic review, but how do we make sure it doesn't prime these stereotypes and biases that hurt minorities?
Can I take a step?
Yeah.
So this gives me a chance to respond to Juan as well. I want to emphasize that I'm not Ward Connolly. I do believe that race is highly salient in American society on the issue of access to higher education, undergraduate education. I really haven't gotten into the data on graduate school. I argue that places and the other reforms I've recommended is a better mechanism that's more legally palatable and politically palatable. But when you have an issue of straight up racial discrimination, which racial profiling is, yes, of course, race is the main thing going on. It's racial discrimination, and in opinion polls, most Americans say racial discrimination is wrong. You have majority consensus there. On affirmative action, white folks experience affirmative action, race-based affirmative action, as discrimination against them. So I just want to clarify. I'm not saying we should be post-racial for all circumstances. When it comes to employment, studies that I've looked at, one thing that might help is just priming employers, apprising them of their own biases and discrimination might help. Like, do you realize that, tests show you do this, that you treat a person, and the last thing a white person in this country wants to be is a racist, right? And there's studies that show when jurors are told that African Americans are often treated differently, they're primed that way, then they work harder in the process to not do that. So that kind of work might help with the kind of garden variety rank discrimination that is out there in the culture and in employment.
Can we get just one last question?
Hi, I'm William Haberly. I'm at Case Western Reserve. My question to you guys, and I feel it's something that should actually come at the front of these discussions, is what is race? You talk about a lot of data, and my question is, what is the category that you're using to define race? Is it valid, and what does it actually mean when you use that term? Because I think we're not scientifically talking about very valid measures.
Maybe Juan, do you want to talk about it since you've been?
Most of the data, all the data we've been using and all the case law that we use, the evidence is self-identified data on the census. You are the race that you say you are.
What does that actually mean? Does that give us any valid data? I could say on a census that I'm white. I could also say that I'm Native American. I can also say that I'm Asian.
Well, I guess from my perspective is, how are you being treated? Are you being excluded from an opportunity because of perception that you are either one of those categories? Because it's not just how you identify yourself, it's also how others identify you from the perspective of civil rights enforcement. But all the data that we use across the board, with all of its flaws, is self-identified census data. It's almost like the Bible in all these federal cases.
Okay, thank you. We have run out of time. Join me in thanking our panelists.